My name is Diana. I'm a regulated Canadian immigration consultant and member in good standing with the ICCRC. And today I bring you one more immigration question of the day video. Today's question is, what happens to my daughter who was born in the US after we did our landing? My wife and I did our landing in February 2020, shortly after we came to know we are pregnant. My daughter was born in the US in December 2020. We still live in the US and plan to move to Canada as soon as I get a job. Would my daughter need to be added to our PR dependent list, or would she live with us as an American citizen, or would I get to apply for a dual citizenship? Thanks so much for your question. Uh, your daughter doesn't have a claim to dual Canadian citizenship, Canadian US citizenship yet, because for that to have happened, you needed to already be a Canadian citizen yourself to be able to pass Canadian citizenship to your child born outside Canada. And that's not the case, right? You're a permanent resident. You talk about doing your landing, so you are a permanent resident, not a Canadian citizen yourself. So no, your daughter, unfortunately, is not a Canadian citizen yet. So that's not an option. As a permanent resident, you would have to sponsor her to obtain permanent residence. In fact, if she had been born in Canada, she would have been granted Canadian citizenship by birth, so that wouldn't be an issue. But because she was born in the US from permanent residence, from Canadian permanent residence, you would need to return to Canada and file a dependent child sponsorship to sponsor your daughter to obtain permanent resident status. And yes, you would need to return to Canada to do that. One of the eligibility requirements under Section 130 of the Immigration Refugee Protection Regulations requires the sponsor to be residing in Canada at the time of the application and also throughout the application. There's an exception, slight exception, for Canadian citizens who are required to sponsor a spouse, common law partner, cordial partner, or dependent child if they are outside Canada, if the sponsor is outside Canada, as long as they intend to return to Canada when the sponsored person obtains PR status. If the sponsored person obtains PR status, but that exception only applies to Canadian citizens, and you're, based on what you wrote, you're not a Canadian citizen yet, you're a permanent resident. As such, to be able to submit that dependent child sponsorship application, you need to return to Canada first and be residing in Canada to be able to submit the application to be a sponsor and to sponsor your child for permanent residence. So I hope I was able to clarify this question. And just one more thing. If the daughter gets granted entry as a visitor because she's an American citizen, she doesn't need an ETA or TRV to enter Canada, but if she does get to enter Canada as a visitor, you so you can then file that dependent child sponsorship application. Don't forget to extend her status as a visitor to submit that application as well, because a permanent residence application in itself does not grant status in Canada, not even implied status. So make sure to extend your daughter's status in Canada. Make sure she gets legal status. She continues to have legal status throughout the processing of our application, because dependent children sponsorship applications can take as much as 12 plus months to be processed. So I hope I was able to clarify this question. Thanks so much for asking it. And feel free to contact me. I am actually specialized in family class sponsorship applications. So feel free to contact me to discuss your case in more details through an initial consultation and to start this process as soon as possible.